We start with this. Accountability Now continues to push for a Chapter 9 institution to investigate and prosecute serious corruption in South Africa. The director of Accountability Now, Advocate Paul Hoffman, presented the proposal to Parliament's Joint Constitutional Review Committee on Friday. He joins us now. Advocate, thank you. Before we get into this, your comment, please, on the Bosasa liquidator investigating all sorts of people apparently involved in a hit. Him and his son now dead. This is Corne Murray. And of course, this is what you care about, possibly high-level corruption here. I mean, Bosasa was implicated in state capture. Ministers were implicated. We don't know, but what are you thinking when you heard that news, or when you hear that news?
Yes, I'm afraid all of the press that I've been able to get my hands on today seems to suggest that this shocking incident is indeed a deliberate hit, a politically or economically motivated taking out of a person who has had to deal in his capacity as the liquidator of Bosasa, and also in some of the work that he's done in the field of business rescue, with controversial people and with people who have been accused, rightly or wrongly, of corrupt activities. So it really does, unfortunately, give credence to the tag that South Africa is a gangster state. It's not what we want, and one hopes that the authorities will be galvanized into doing what we asked them to do in Parliament last Friday, which is to jack up the anti-corruption machinery of state in a way that renders it constitutionally compliant and more efficient and effective than it has been since the Scorpions were closed.
So, Advocate, you want a Chapter 9 institution, a new one. Help us understand, because the prosecuting authority has a special unit and that's being made permanent. The Hawks investigate and they work with the prosecutors, presumably the SIU and Auditor General there as well. What did you tell Parliament? Because the MPs asked, why do we need something else?
Yes, no, certainly there was a fear of duplication of effort, but the source of our plea is not something that we dreamt up on our own. Exactly 12 years before the day on which we made the submission to Parliament last week, the Constitutional Court handed down a very important judgment in the Glenister litigation. It's a case that is called Glenister 2. And in that judgment, the court said to Parliament, we don't like the Hawks as a suitably independent and effective and efficient anti-corruption body. We think you should go back to the drawing board. And here, they said, are the criteria by which you ought to build your anti-corruption machinery. And they laid down a lot of criteria. I think there's time for the 5 most important. Your anti-corruption machinery needs to be specialized. It must only do corruption work, nothing else. The staff needs to be properly trained so that they are smarter than those involved in corruption. Need to be adequately independent so that they can work without interference, without influence, without impedance. They need to be resourced in a manner that is guaranteed, and they need to be secure in their tenure of office. So those 5, the STIRS criteria, specialized, trained, independent, resourced, and secure, are the criteria that the court has laid down. Yeah. But it says, we are not Parliament. We want you to make the reasonable decision of a reasonable decision maker in the circumstances. And that has just not happened. Certainly on the Zuma watch, and not since. Yeah.
Why does it have to be a Chapter 9 institution?
We've hit upon the idea of making it a Chapter 9 institution, and it's just a suggestion. It's not cast in stone. There may be ways of doing it. But we think that the secure tenure of office is best, that's the last S in the STIRS, is best achieved by housing your anti-corruption entity in Chapter 9, because Chapter 9 institutions have constitutionally guaranteed independence, and they are certainly much more difficult to close down than it was to close down the Scorpions. Scorpions were just a creature of statute, and they had to close down because the majority in Parliament voted for their closure.
I'm glad you mentioned the Scorpions, Advocate. Sorry to cut in there. We're just running out of time. And I'm so glad you mentioned the Scorpions, because I was going to say what's different and what would be the same, because when you were talking, it sounded very much like the Scorpions. You've answered that. Very quickly, the Special Investigating Unit seems to be moving pretty quickly of late. I mean, looking at the Lotto corruption and auctioning off Terry Peto's house because she didn't object to that. But then you're not seeing arrests. So would this result in a movement in tandem, as it were?
No. Well, the big difference between the Scorpions and a Chapter 9 institution is that the Scorpions were closed down by a simple majority in Parliament. A Chapter 9 institution couldn't suffer that fate. The SIU is not part of the Criminal Justice Administration. It is not independent. It only acts when the president gives it a proclamation telling it to look into a particular problem. And it does not arrest anybody or prepare a docket for the prosecution service. So those are the differences that make us think that it would be far better to have a single unit in Chapter 9 that is able to investigate and prosecute serious corruption. Not all corruption. We think 5 million rand would be a suitable cutoff point, but that's for Parliament to decide. That's why they're there. It could be that they would come to 10 million or 1 million. It's really a question of addressing the endemic and systemic serious corruption in South Africa that would require the appointment of a body that is STIRS compliant and therefore a body that is in accordance with the law. We don't have such a body now.
All right, we will follow this closely. Thank you, Advocate, and see if it leads to a constitutional review. That was the Director of Accountability Now, Advocate Paul Hoffman.